Most countries have a single document you can hold in your hand and call their constitution. The UK doesn't, and yet the constitution is real. It functions every day, and understanding its nature is the foundation of public law. Think of the UK constitution as a hub with several key features radiating out from it. We will work through each one in turn, starting with the most fundamental. This constitution is uncodified. The most striking thing about the UK Constitution is what it isn't. It isn't a single codified document. Unlike the United States, Germany, or France, the UK has never had a constitutional moment where its rules were gathered together and formally enacted. Instead, the rules of the Constitution are scattered across centuries of statutes, judicial decisions, and political practices. This happened because the UK's constitutional order evolved. Through the Glorious Revolution of 1688, the Great Reform Act of 1832, and countless other developments, rather than being designed from scratch. That evolutionary character defines everything else about it. If the Constitution is not in one place, where is it? There are four main sources. First, statutes, acts of Parliament that directly regulate constitutional matters. Examples include Magna Carta 1215, which established early limits on royal power, the Bill of Rights 1689, which settled parliamentary supremacy after the Glorious Revolution, the Parliament Acts 1911 and 1949, which defined the Lord's powers, the Human Rights Act 1998, which incorporated convention rights into domestic law, and the Constitutional Reform Act 2005, which created the UK Supreme Court. Second, the common law, judge-made principles developed through cases, particularly around the prerogative powers of the Crown and the fundamental rights of individuals. Third, constitutional conventions, political rules we will look at shortly. Fourth, authoritative works. Writers like Dicey, Bagehot, and Erskine May are treated as persuasive guides to constitutional practice, which is unusual in a common law system. Parliamentary sovereignty is the central organising principle of the UK Constitution. As Dicey described it in his 1885 work, The Law of the Constitution, Parliament has the right to make or unmake any law whatever, and no personal body is recognised by the law as having a right to override or set aside the legislation of Parliament. In practice, this means two things. First, Parliament can legislate on any subject matter. There is no topic beyond its reach. Second, courts apply acts of Parliament as they find them. They do not have the power to strike down primary legislation as unconstitutional, the way the US Supreme Court can. The courts confirmed this in cases like R. Jackson v. Verive, Attorney General 2005, where the House of Lords upheld the Hunting Act 2005, passed under the Parliament Act's procedure, though several judges noted in obiter that parliamentary sovereignty might have theoretical limits. The Human Rights Act 1998 creates a partial qualification in practice. Courts may issue a declaration of incompatibility under Section 4, but this does not invalidate the statute. It merely signals to Parliament that a review is appropriate. The rule of law is the second of Dicey's twin pillars. Dicey identified three meanings: no punishment without breach of the law established in the ordinary courts, equality before the law, everyone, including government officials, is subject to the same law, and the Constitution is the result of the ordinary law of the land. In modern terms, the rule of law requires that public bodies act within their legal powers, that individuals can access independent courts, and that the law is certain and prospective. The Constitutional Reform Act 2005 placed a statutory duty on the Lord Chancellor to uphold the rule of law and defend judicial independence. Courts police the rule of law through judicial review. If a minister acts beyond their statutory authority or breaches the requirements of natural justice, the court can quash the decision. Conventions are perhaps the most distinctive and puzzling feature of the UK Constitution. They are non-legal rules. They cannot be enforced in court, yet they are treated as binding in the political world. The Privy Council in Madzimbamuto v. Lardner Burke 1969 confirmed that conventions do not have the force of law. Classic examples include the convention that the Prime Minister must command a majority in the House of Commons, the Sewell Convention, acknowledged in the Scotland Act 2016 Section 28, subsection 8, that the UK Parliament will not normally legislate on devolved matters without Scottish Parliament consent, and the convention that the monarch acts on ministerial advice. Why obey them if they are not legally binding? Because breaking a convention carries severe political consequences: loss of office, loss of legitimacy, constitutional crisis. The Sewell Convention was considered in R. Miller, Vice-President Secretary of State for exiting the European Union 2017, where the Supreme Court confirmed that conventions cannot be enforced by courts but are a real and significant part of the constitutional order. The final feature ties together everything we have said. Because Parliament can pass or repeal any law by ordinary majority, the UK Constitution is flexible and unentrenched. There is no special procedure, no supermajority, no referendum requirement baked into the Constitution itself, needed to change even the most fundamental rules. The Fixed Term Parliaments Act 2011, for example, was simply repealed by the Dissolution and Calling of Parliament Act 2022. This flexibility is both a strength, it allows rapid adaptation, and a vulnerability. It means fundamental rights and structural protections can be altered by a simple parliamentary majority. Academic debate continues about whether some statutes, like the Human Rights Act or the Devolution Acts, should be treated as having a higher constitutional status. And Lord Hope in Jacksonville for Attorney General suggested the rule of law itself might constrain Parliament in extremis. But as the law currently stands, no statute is formally entrenched. Before we recap, here is a check for understanding question. The Fixed Term Parliaments Act 2011 was repealed by an ordinary Act of Parliament in 2022. Which feature of the UK Constitution does this best illustrate? Is it A, Parliamentary Sovereignty, B, the rule of law, C, Constitutional Conventions, or D, Separation of Powers? The answer is A, Parliamentary Sovereignty. The fact that Parliament could simply pass a new act to repeal an earlier constitutional statute without any special procedure is the clearest demonstration that Parliament can make or unmake any law whatever. The UK Constitution is uncodified, spread across statutes, common law and conventions, held together by two great principles: parliamentary sovereignty, which means Parliament can make or unmake any law, and the rule of law, which means everyone, including the government, must act within the law. Your modules, mapped to your uni, explainer videos for every topic, a tutor that knows your course, essay writer for your essays and graded, case briefs, flashcards, annotations. Try it free for 7 days, link in the description.